Thank you for joining Jennifer Strauss and Associates in our 2019 Webinar Wednesday series. We're coming to you live from downtown Washington, D.C. Our webinars are every Wednesday. You can find the upcoming schedule on our website. Past webinars and all recordings are also on our website and on our YouTube channel, along with over 160 other recordings on federal contracting topics. All are complimentary. If you have questions for our speaker today, you can email her directly with the contact information you'll see on the last slide. Right, this is just a little bit about us. We are a Washington, D.C. based firm and provide services for federal contractors. This ranges from market analysis reports to proposal writing and also post-award compliance. More information is on our website. Please visit us there. We do offer advertising in our newsletter, so you can reach out to this email if you'd like more information on that. All right, our speaker today is Devon Hewitt. She's going to be covering FAR compliance best practices for prime. Thank you for joining us today, and I'm going to go ahead and hand it over to you.
Thank you. Next slide. The FAR is the general regulations that apply to government procurement. Specifically, the Federal Acquisition Regulation is promulgated by something called the FAR Council, and it has representatives from GSA, DOD, and NASA. The FAR is comprised of 53 parts. One part addresses general acquisition policies. Following that, there are several parts that address planning. Then there are several parts that address exactly how a procurement must be conducted, and the remaining of the FAR parts address contract performance. The FAR also includes agency supplements. Not every agency supplements the FAR. The most well-known is the DFARS, which is the Department of Defense supplement to the FAR. The FAR supplement provisions must be consistent with the FAR, so they really are supposed to just fill in certain gaps. FAR clauses in the FAR contain prescriptive language requiring other FAR clauses to be included in a contract, a prime contract. And those clauses are really divided into two, solicitation provisions and then clauses that apply to contract performance. So there really are two types of quote-unquote clauses or quote-unquote provisions in a contract or a solicitation. The solicitation provisions will drop out. The clauses addressing performance will stay in. How a contracting officer knows to include the various clauses, again, there's prescriptive language in the various parts of the FAR, but there's also a FAR matrix at the end of the FAR, which includes every clause and indicates whether the contracting officer must include it in certain types of contracts, in certain contexts, above certain thresholds, etc. So the contracting officer, as well as the prime, can look at that and have an understanding about where its FAR obligations are going to come from, and maybe even challenge a prime contract inclusion of a certain FAR clause if it's included in the prime, or the prime notices that the matrix does not require that to be included in the clause. Next slide. So the FAR does not apply directly to government contractors. It applies to the government, and it instructs the government what to do in the federal procurement. It is only applicable to executive agencies. So only executive agencies have to comply with the instructions in the FAR, and there are certain key exceptions, the FAA, which has its own acquisition regulation, and the U.S. Mint. The other tenet of applicability is appropriated funds. So, for example, concession contracts on bases, which are self-funded from the proceeds of what they sell, are not subject to the FAR. And certain types of agreements, other transaction authority agreements, are not subject to the FAR, and indeed that is why they are so popular, particularly now, because they are not subject to the constraints of the FAR. Grants and cooperative agreements, purchases or leases of real property. Now, the FAR does not directly apply to subcontractors, just like it doesn't directly apply to contractors. The compliance obligations to the FAR, generally speaking, come from the contract itself. So a subcontractor will only be required to comply with the FAR clause if that clause is included in its subcontract. Similarly, a prime contractor will only need to comply with the FAR clause if it is in its prime contract. Now, unfortunately, it's not as black and white as that, and we're going to talk about that, but that's the general rubric under which the FAR operates. The FARs have clause dates in them, so they can be revised and are reissued under a new date, and they're amended. And there sometimes is an issue about whether or not a FAR clause in a prime contract is enforceable if there has been a subsequent statute that has amended that FAR clause, but the new FAR clause has not been promulgated. That comes up in a couple of instances. There's also issues where there has been an amendment to the FAR clause, and does that allow the prime contractor or the government to amend the contract to include the new version of the FAR clause? So those are issues to be aware of. And a lot of FAR clauses have alternates. So at the end of the FAR clause, there may be something called an alternate that prescribes alternate language to be inserted in a certain variation of the contract. They'll also have blanks that need to be filled out. And on rare instances, an agency can do a deviation from a FAR clause. They can make a pronouncement by the agency head that for a particular reason, this agency in a circumstance is going to actually deviate from the FAR requirement and impose another requirement. So this is the baseline against which prime compliance will be measured. Generally speaking, the FAR, generally speaking, what's in your contract. However, there are gray areas, and I'm going to focus on that. Next slide. As I mentioned, the FAR instructs an agency official to include certain FAR clauses in a prime contract. Most primes know this, but nearly all FAR clauses included in a prime contract are non-negotiable, and that includes solicitation provisions and FAR clauses. However, as I mentioned, a lot of those FAR clauses have alternates. A lot of the FAR clauses have blanks. So there is some ability to work with the clauses. In addition, there is an opportunity for a prime contractor to influence what is included in the solicitation and thereafter maintained in the contract. When a government issues an RFI, or request for information, or a draft RFP, contractors can give feedback and say, no, this clause really doesn't apply to this type of procurement, or why is the government including this clause? Another way to do that is that you will have a clause, like an IP clause, but you want to clarify how that would apply to a prime. So there is another clause that allows a prime to identify the types of IP it intends to provide the government and what rights it claims it will give the government and is entitled to give the government and is entitled to keep for itself. So while they really can't be negotiated, they can be manipulated. I don't know if that's a distinction with a difference, but they're not completely static, is what I'm saying. And again, if you refer to the FAR matrix, you can point out that some are not even needed to be included, or point out, the way it might apply to your offer. Most FAR clauses implement general policies associated with the government's role in distributing taxpayer dollars. And when the government does that, it has an obligation under a number of federal laws to promulgate and support and advance various public policies. And most of those are equal opportunity, affirmative action, labor, supporting collective bargaining agreements, making sure that contractors comply with various ethics issues, anti-kickback, no bribery, have a drug-free workplace, make sure they don't pollute waters, etc. That's a large part of the FAR clauses that are flowed down. and is generally a focus of enforcement. The other ones are a little bit more contract performance based, whether you need certain security provisions, whether you can include certain foreign manufactured items in your products that you deliver to the government, whether you have to compensate your people at a certain level, etc. Those are also included in a contract, but what primes need to know is that these type of FAR clauses, the ones that advance socioeconomic and public policy objectives, are those that will almost always be included in every contract, and if they are not, are likely to be deemed included pursuant to something called the Christian Doctrine, or otherwise applicable by virtue of another statute administered by another agency. So, for example, the Department of Labor has certain laws and regulations also addressing equal opportunity, affirmative action, etc., or define a role of a prime contractor in such a way that certain labor requirements or record-keeping requirements apply to them. So the focus should be on these types of issues. Many factors determine what FAR clauses will be included in a prime contract. As I indicated, there's a matrix, and the value of the contract, the nature, the type of clause, all depends, all affect what clause is included, and there is a roadmap for agencies and for primes included in the FAR in that regard. Next slide. The Christian Doctrine, which I refer to, relates to a case in which a landlord complained about the government's interest or its termination of the contract, termination of the lease. And the government said, well, we always have a right to terminate. We're the government, and there might be government interests that mandate the termination of a certain contract. And the landlord says, no, you can't. You signed up for a lease. My charges and my anticipation and benefits that came out of this lease were based on my view that the government made a commitment to be in the space at a certain price for a certain amount of time. In that case, the judge stated that no, the standard termination for convenience clause was actually implied in the nature of the contract, which was the lease, as a matter of law. And so the landlord was bound to it, even though it was not in its contract. Now, this is typically something that arises in a litigation context, where parties are disputing whether or not one particular clause is included in the contract or not. And so it will ultimately be subject to a judge or a court determination. And the courts have typically said that it will be incorporated by reference if it's something that the contracting officer should have included initially, and also if the clause reflects, quote unquote, some deeply ingrained aspect of public procurement policy. Now, if you ask me, termination for convenience is not really a deeply ingrained aspect of public procurement policy. I think in that context, it was the ability of the sovereign to do what it needs to further the interests of its public. So perhaps that's how those two were aligned. But they are used for certain other clauses. It has been used, the doctrine has been applied in termination for convenience, default provisions, use of government property, protests after award. The conventional wisdom is that it would apply to, again, those socioeconomic provisions that we've discussed, the affirmative action, equal employment opportunity, because those are required by statute through other agencies as well, or even by state law for that matter. So I think it's good for contractors to assume that if it's not in their prime contract, that those types of obligations are not, are going to apply to them, notwithstanding the fact that they may be omitted from a prime contract. Next slide. So one way to comply with FAR clauses that are in prime contract is to flow them down. Because unless a prime contractor is performing the entire scope of statement of work, some of the statement of work is going to be performed by another contractor, which will enter into a subcontract with the prime contractor. And so the liability associated with that work should follow the entity that is performing that work. And in some ways, it's very easy for the prime contractor because many of the prime contract clauses that have to be flowed down to the government, flowed down to a subcontractor, say they have to be flowed down to a subcontractor and expressly state in the last paragraph of that clause that the prime contractor must include substantially similar language in any subcontract that it lets or awards in the procurement. Now, there may be an issue about a relationship a prime contractor may have with an entity that may be a 1099 or a vendor or another type of entity, and whether or not that particular organization really is a sub that really needs to have that flow down clause in that contract. And that generally depends on whether or not that vendor, entity, person is actually performing a part of the scope of work. I mean, if there is some third party that has a relationship with the prime that is performing part of the statement of work, that entity person is a subcontractor. And in that regard, the prime must include those subcontract provisions in the subcontract. And if they don't, they could be terminated for default or even worse, depending on the nature of the particular clause. Now, it may be prudent, and indeed often is prudent, for a prime to flow down other clauses that by their own language don't require to be flowed down to subs, but a prime really needs to, because again, it attaches to the work that the sub is performing, such as if you're going to manufacture a widget and you need to get bolts and screws from China, is there a restriction on doing that, or does the sub have to quote unquote buy American and only include in the widget bolts and screws that are manufactured in the United States? So in order to comply with that in the prime contract, the prime contractor really needs to make sure the subcontractor complies with that as well. Next slide. And there's a process to doing so. Most prime contractors just flow everything down or include a statement saying that, whatever obligations we have under the prime contract, subcontractor, you fulfill them. And that's generally what's typically done in the industry. And also, on top of that, though, you do have to include a substitution provision where you say, where the clause says contracting officer, it means, prime contractor, or where it says contractor, it means subcontractor. I mean, at a minimum, that's what's typically done because primes don't want to spend the resources of parsing through all the clauses and figuring out what applies to the particular subcontract. It won't even do that with respect to what applies to it. So there's a general feeling that whoever receives all these FAR clauses will work it out. But there are issues involved when you flow down a FAR clauses. FAR clauses address issues that you typically would include in a commercial subcontract. Terminations, disputes, changes, stop work orders, those sort of issues come up in any relationship, any contracting relationship. So a prime and a sub will likely address it. And if they just flow down in an appendix all FAR clauses, it may be that that same topic is included in one of the FAR clauses, but treated differently. And so you have an inconsistency. And then the issue is, well, which one has precedence? And the subcontract may say, well, this has precedence over the other one. Well, that may make it clear, but that may not be the intention of the parties. It may be that they never intended that provision to trump the other provision, or they intended them to work together and not one have supremacy over the other. So really the most important thing for a prime contractor is not to flow everything down, but to ensure that what it flows down really is consistent with what it intends the subcontractor to do and what's addressed in the subcontract itself. Next slide. So here are the best practices. As I said, most primes want to flow everything down. And there's nothing wrong with that from a prime contractor's perspective. You might want to have the ability to amend that per Christian doctrine, so say that up front. but ensure that the timeframes that are flowed down are adequate for you to meet your obligations. So if you have to submit something in 30 days, don't have the subcontractor submit it in 30 days, have them submit it in 20 days to you. And as I said, you need to be consistent with what you intend the obligations of the subcontractor to be, and make sure that if you want them to continue to perform, you say that in your disputes clause or in the prime contract, even though it's not said in the FAR disputes contract. And lastly, I didn't focus on this, next slide. Every prime contractor should have a code of business ethics and conduct where it informs its people and its subcontractors about the commitments to comply with these FAR clauses and how it will do so. I mean, small businesses just need to have the code, but larger businesses have to commit to training and other checks and balances within the company to ensure that its people actually follow through on their obligations and that its subcontractors and vendors do as well. And part of that also is not only to train and be aware and to practice all these good principles, but to disclose to the government when there's been something that has fallen through the cracks and was not actually compliant with some particular FAR instruction or provision. And that also has to be flowed down to a sub. So it's not only complying and ensuring compliance by flowing down FAR clause, it's by establishing a compliance program for your entity itself so that you ensure not only your subcontractors are complying, but your people are complying or are instituting or implementing procedures that would ensure or give the government confidence that the entity is in fact complying with those FAR provisions included in the prime contract. That's it. Thank you very much for your time.
Thank you so much for joining us today. If you have any questions, you can reach out to our email or phone number shown on your screen. And this concludes the webinar. Thank you.